The state of Georgia regulates alcohol from manufacturing to selling to actions resulting from its use. This includes how alcohol is sold, to whom it may be sold, when it may be sold, the consequences of violations of its regulations, and the placement of liability on violations of its regulations. Georgia defines its expectations through the Georgia Code. Authority for enforcement of Title III of the Georgia Code rests with the Commissioner of the Department of Revenue. Since those who sell alcohol in Georgia are licensed by the state, it is important that they and their employees are familiar with laws and rules that govern the sale of alcohol. The purpose of this training module is to provide basic information for persons who may sell or serve alcohol to consumers, users in the state of Georgia. The state of Georgia does not require servers, i.e. bartenders, to be licensed. Businesses and even occasional servers, i.e. caterers, are required to be licensed to sell and or serve alcohol and are expected to be familiar with state requirements. The information in this training is in addition to local regulations. Training objectives. By the end of this training, you will 1. Be able to discuss Georgia law as it relates to on-premise selling and serving alcohol. 2. Be able as an employer to provide ongoing training for employees to ensure compliance with all Georgia regulations related to serving and or selling alcohol. 3. Know the responsibilities and liabilities for serving and or selling alcohol in the state of Georgia. To help you better understand alcohol regulations in Georgia, this training is presented in two major parts. Part 1, shops and situations that sell or provide for serving and drinking the alcohol on site, i.e. a bar, catered event, or sports arena. Part 2, shops that sell alcohol by the bottle and do not allow for consumption or use on site, i.e. a liquor store or a grocery store. Georgia law. Laws related to the selling and serving of alcohol in the state of Georgia are found under the Georgia Code. It provides general provisions including 1. Definitions, 2. Penalties for violations, 3. Enforcement authority, 4. Regulation sources, 5. Prohibited activities, etc. Under Georgia Code, the Commissioner of the Department of Revenue is responsible for the development of rules to enforce the law. These rules are based on the laws and are enforceable as the law is enforceable. Furthermore, Georgia Code calls for all persons falling under the state laws to also fall under the laws and ordinances of their local, city, and or county, and those of the federal government. Although the information in this training is not all of what a server of alcoholic beverages needs to know, it does, however, provide the more important aspects under Georgia law and regulations. Georgia regulations. Rules for the sale and consumption of alcohol in the state are based on laws passed by the Georgia General Assembly and are established by the Alcohol and Tobacco Tax Division of the Department of Revenue. In addition to the state laws and rules, local, city, and or county ordinances which are locally enforced control the sale and serving of alcoholic beverages within their borders. Penalty for violation of law. Violators of these rules will be charged with a misdemeanor. If found guilty for knowingly violating the rules, punishment may be fines, seizure of illegal alcohol, suspension of license, loss of license, or non-renewal of license to serve or sell alcohol. Covered beverages. If you serve alcohol, you are expected to know the laws and rules about serving alcohol and the different beverages regulated under these laws and rules. On the next slide is a listing of the beverages covered by these laws and regulations. 1. All alcohol, distilled spirits, beer, malt beverage, wine, or fortified wine intended for human consumption. By type, it would include the various types of alcohol products such as bourbon, gin, and vodka for distilled spirits, Chardonnay and Pinot Noir for wine, and Lager and Ale for malt beverages. Also included are distilled spirits or any alcoholic beverages obtained by distillation or containing more than 21% alcohol by volume, including but not limited to all fortified wines. There are other alcoholic beverages covered by these laws and regulations. These include hard cider, which is an alcoholic beverage obtained by the fermentation of the juice of apples, containing not more than 6% of alcohol by volume, including but not limited to flavored or carbonated cider. For purpose of this regulation, hard cider shall be deemed a malt beverage. The term does not include sweet cider. Malt beverage is an alcoholic beverage obtained by the fermentation of any barley, malt, hops, or any other similar product or any combination of such products and water containing not more than 14% alcohol by volume, including ale, porter, brown, stout, lager, beer, small beer, and strong beer. This term does not include sake, known as Japanese rice wine. Mead wine or honey mead is a fermented alcoholic beverage made from honey that may not contain an alcoholic content of more than 14% by volume or total solids content that exceeds specified sugar content. Wines, champagnes, combinations of such beverages, vermouths, special natural wines, rectified wines, other light products, and sake, which is made from rice, is any alcoholic beverage containing not more than 21% alcohol by volume made from fruits, berries, or grapes, either by natural fermentation or by natural fermentation with brandy added. Let us review what we have learned in this training thus far. 1. We talked about the Georgia law that governs the selling and serving of alcoholic beverages. 2. We discussed the penalties for violating these laws. 3. We also listed the types of beverages that these laws cover. Now, let's look at licensing, hours of operation, and age of personnel serving alcohol, and legal age of consumption of alcohol beverages. Licensing. The person or persons responsible for the sale of alcohol must be licensed to do so. Their applications and license must have the same name and address that are provided on their applications to their governing county or city authorities. Also, applicants must specify the address of the place of business for the license. If a business sells alcohol at different locations and sites, each location and site must have a separate license to do so. The license is valid for 1 calendar year. An application for the renewal of a license is due by November 1st of the active license year. In addition to the other information discussed about licensing requirement, you should know that licenses are not required for service bars or portable bars that are only used exclusively for the purpose of mixing or preparing alcoholic beverages, drinks, and those bars can only be accessed by employees of the licensed business and from which alcoholic beverages, drinks are prepared to be served on the licensed premises. It is important to know that any alcoholic beverages kept, stored, or found at the licensee's place of business or warehouse, it shall be presumed to be the licensee's property. Therefore, any illegal beverage found there is a violation of the license. There are some general regulations about hours of operation of venues serving alcoholic beverages that are listed on the screen. Hours of operation must fit within the times determined by the licensing authorities, state or local governments. Businesses serving alcohol may not open in violation of county or municipal laws or ordinances or in violation of a special order of the Commissioner of Revenue. Specific times of operation may not be before 8 o'clock a.m. or after 11:45 o'clock p.m. If permitted by county or city laws or ordinances which allow for Sunday openings, businesses shall not open before 12:30 o'clock p.m. or after 11:45 o'clock p.m. In addition to being open between certain times of the day, neither owners nor employees may themselves or permit others to be in the place of business, neither in violation of county or city ordinances, nor in violation of a special order of the Commissioner of Revenue. Specifically, no one may be in the place of business before 6 o'clock a.m. or 30 minutes past closing times. On Sundays, no one may be in the place of business before 10:30 o'clock a.m. or 30 minutes past the closing time of 11:30 o'clock p.m. There are some expectations to when a company that serves alcoholic beverages may have employees or its agents in the business outside the permitted times. Listed on the screen are some of the activities that could not take place during regular business hours and must be conducted when the facility is closed. 1. Responding to emergency situation, for example, a fire or burglary. 2. Taking inventory. 3. Making repairs. Or 4. Renovating. However, all door entrances to the place of business must have a posted sign that reads, "Closed, no customers allowed on premises." Now let's talk about the Dram Shop Act. State of Georgia Liquor Liability. The term dram shop is historically known as a place of business that sold alcoholic beverages such as bars, taverns, and saloons in the past. Dram shops were not held responsible for the actions of its customers after they drink alcoholic beverages, leave the property, and become involved in accidents or in altercation. Today, however, many states have imposed some form of responsibility on dram shops and other establishments that serve alcohol, stating that the server of alcohol may be held at fault for the actions of an intoxicated customer under certain conditions. In layman terms, the state of Georgia dram shop laws provide that generally the use of alcohol, not the sale or providing, is the normal cause of injury, death, and or property damage caused by an intoxicated person to him or herself or another person. The alcohol server is not liable for the actions of a person 21 years of age or older who becomes drunk. Liability may occur if the server knows that the visibly intoxicated person will be operating a motor vehicle after alcohol use and that person is involved in an accident or altercation resulting in injury, death, or property damage. Server liability also may occur if a person sells or provides alcohol to any person that is under the legal drinking age. However, liability may not occur if it is determined that the sale of alcohol to an individual was done so because that individual provided a fake ID to state that they were above the legal drinking age. If this occurs, this will serve as proof that the person serving the alcohol only provided the alcohol after following the legal procedure of identifying customer as being of the legal drinking age, did not provide alcohol knowingly, willfully, and unlawfully. Let's look at another aspect of the regulation. If the owner of a property that does not regularly serve or sell alcohol does not give permission for a person to consume alcohol on their property, the owner will not be held responsible for the actions, including injury, death, or property damage caused by intoxicated individuals. As we review the Dram Shop Act, it can be seen that it is important for the server of alcoholic beverages to establish that the person is of legal age to be served alcohol, and it is also important that the server knows the signs of intoxication. A person might ask, how do I know if a person is intoxicated? What are the signs that I should look for? The Merriam-Webster Dictionary defines intoxication as an unhealthy state that is or is like the condition of being drunk. In the state of Georgia, alcohol intoxication is legally defined as having a blood alcohol level above the stated legal limit. The limit is a blood alcohol content, BAC, of 0.08% for general drivers at least 21 years of age, 0.04% for commercial operators, and 0.02% for drivers less than 21 years of age. Here are some steps that help determine if a person shows signs of intoxication. Step 1. Size of each person's potential for intoxication based upon their physical characteristics. Although alcohol affects everyone similarly, the speed at which it does so will be different based upon these physical characteristics: size, gender, the rate of consumption, the strength of each drink, the amount of food, and the additional use of drugs all are to be considered when determining how quickly alcohol may be affecting someone. Step 2. Watch for a person's inhibitions to become lowered. If someone is becoming more talkative and beginning to lose some control of knowing how far they can go in a social setting, they are showing the first signs of intoxication. Louder behavior than usual and even mood swings are also possible warning signs. Step 3. As they become increasingly intoxicated, a person will progress through the stages of poor judgment. This is inappropriate behavior that their normal personality would not allow for them. Foul language, off-color jokes, and overly flirtatious behavior are signs of poor judgment. Also, if their rate of consumption begins to increase or they participate in drinking games, these could also be signs of poor judgment. Step 4. Once people drinking alcohol begin to show signs of physical impairment, first get them to stop drinking any more alcohol. Some beginning signs of physical impairment are slurred speech, slow or clumsy movements, swaying, dropping objects, for example, goods, money, keys, or forgetting thoughts in mid-sentence. Talking slowly or moving slowly or in a nearly robotic fashion are signs as well. Signs such as glassy or red eyes or the odor of an alcoholic beverage on breath are not signs of visible intoxication, but are signs or indicators of alcohol use or possibly other things such as allergies or even a medical condition. Step 5. If a person shows a loss of motor control or function or poor coordination, they must not be left alone, and they could become a danger to themselves or others. Stumbling or swaying, having difficulty with depth perception and dropping things repeatedly, or having difficulty picking them up are signs that the person has progressed to this level. Step 6. Remember that it's possible for people to develop a tolerance for alcohol, but that doesn't mean that they are not legally intoxicated. It just means that visual recognition is more difficult. For some people with exceptional tolerance, drink counting may be the only way to access intoxication, but this is not without problems. Redness in the body's extremities can also be a sign of alcohol use, but such flush reactions are not a sign of visible intoxication. For some people, a single drink will cause this reaction. In the final analysis, the decision to serve or not to serve may be a judgment call based on experience of the server. In order to keep alcohol out of the hands of individuals that are not allowed by law access to alcoholic beverages, waitstaff, bartenders, servers, and any other person engaged in the sale or distribution of alcoholic beverages should at all times request from the customers or individuals seeking to purchase or consume alcoholic products a valid ID. That validates the current age of consumer, customer. Do not depend on looks. Check IDs of customers who may appear younger than 40 years of age. Remember that the legal age for alcohol consumption in the state of Georgia is 21. In the state of Georgia, the only legal forms of identification include valid state driver's license, valid state ID, valid military ID, or valid passport. All accepted forms of ID should contain a picture of individual requesting purchase. Failure to verify age by valid identification could result in fines for the server, restaurant, or establishment providing alcohol. Criminal charges can be made against the individual or establishment that has provided the alcohol without engaging in proper age verification. Loss of the establishment's liquor license is also possible after 2009. Any Georgia's driver's license or state ID for anyone under the age of 21 is printed in a vertical format instead of the normal horizontal credit card style format. It is the law. Check ID. A good rule of thumb, when in doubt, check ID. Always remember these points. It is law that you verify age by ID. ID must have photograph. ID must be of a form legally valid in the state of Georgia. Driver's license with photograph and date of birth issued by any state or United States territory. State ID with photograph and date of birth issued by any state or United States territory. State of Georgia interim driver's license or state ID with photograph, military ID, passport. Remember, anyone under the age of 21 will have a vertical ID if ID is a state of Georgia ID. Compare facial features, height, eye shape, ear and nose shape, or placement. Ignore weight, hair, and makeup, as these can change. Compare date of birth and expiration date on ID. Pay attention to customer for actions that may indicate that the customer is being dishonest. Facial expressions, eye movements, and body language can often be indicators that the customer is being less than truthful about their age. If you come across a fake ID, immediately alert your supervisor and law enforcement if present. Also, make a notation in the business log under the date and time that the customer presented the fake ID. In order to be a responsible server of alcoholic beverages, you must know the law and govern your behavior according to the law to avoid legal penalties. Let's review this law again as we come to the conclusion of this training. No licensee, employee of such licensee or any person acting on behalf of or with the knowledge of such licensee shall give, sell, or offer to sell, furnish, cause to be furnished, or offer to furnish any alcoholic beverages to any person who is under the lawful drinking age as established by Georgia law. State of Georgia, 560-2-2 25. The penalties for serving or providing alcohol to anyone under the age of 21 can range from criminal charges to the permanent loss of liquor license for the offending establishment. It is illegal for adults to provide alcohol to minors. The adult will typically be charged with contributing to the delinquency of a minor. If convicted, the adult faces a $1,000 fine and up to 12 months in jail. Selling alcohol to minors is also a serious offense, carrying with it up to 12 months in jail and a $1,000 fine. Parents may file a civil suit against an adult who supplied their minor child with alcohol. There are some final points that should be made to help servers understand the law and regulations that govern the sale of alcoholic beverages in Georgia. Servers may not offer a coupon or rebate that would change the price of alcoholic beverages, nor may they accept coupons or rebates from their supplier that would decrease the cost of alcohol to the business. Finally, we want to discuss some venue and server responsibilities that are important under the Georgia law. Awareness of customer activity in and around your establishment is important to providing a safe and pleasant atmosphere for employees and customers alike. If negligent or improper activity is noticed, it is the duty of the server or employee to notify the proper authorities in order to avoid any harmful outcomes to customers and employees. Based on the state of Georgia's dram shop laws, an establishment and its waitstaff can be held responsible for alcoholic-related accidents if it is determined that proper carding and identification was not done prior to the sale of alcohol to the individual or individuals involved in the accident, or if it is determined that alcohol was served to individuals that were deemed to be already intoxicated. This concludes this training on alcohol service training for on-site consumption. The focus of this training for bartending in the state of Georgia. Now that you have completed this video training, please complete the post-training survey. In order to obtain a certificate of completion for this training, mail or fax the post-training survey to the address or fax number on the screen. You can also scan the survey and submit by email to pnewbill@msm.edu. After your survey is received, a certificate will be sent to you to validate your completion of this training module.